NACDL is the association of the nation's criminal defense bar.
At some point, you have to be pissed. You have to be upset. You have to understand that what the DAs and the prosecutors are trying to do is use this rule, 404, to win against your client for stuff that's not in this case. Are you kidding me? That's what's going on. That's what this rule is about. And I'm really happy to have been right after Alona's presentation because she says something that's super important. You have to object. Are you going to win the objection? Come on, man, really? But you have to object. So one of my heroes is Jeff Robinson. I don't know if you've seen Jeff Robinson. Jeff Robinson, I believe, is the deputy legal director at the ACLU. And I've seen him perform and present, and it's amazing. And he tells this story about Batson versus Kentucky, right? So Mr. Batson is in this trial in the state of Kentucky, and he's realizing, oh my God, all of these people who look like me are being kicked off. So obviously Mr. Batson doesn't say, hey, pursuant to a case that's named after me, can you object, right? He doesn't do that. He turns to his lawyer and says, I think something's wrong. The lawyer goes, well, there's no rule against it. So Mr. Batson says, object anyway. Object anyway, right? And so part of what we're going to talk about all through this entire presentation and before is this. If you are fighting these things because you're guaranteed to win, you are in the wrong conference. Okay? We're not going to do that. But sometimes, especially with 404Bs and those arguments, if you mess it up enough, somewhere, sometime, they may say, whoa, we have ourselves some prejudice. We have a problem. But if you just, you just do what we normally do with 404B, it's not going to work, all right? So 404 talks about character evidence, right? Generally not admissible to prove that a person acted in conformity. And 404B is evidence of other crimes, wrongs, or acts can't be used to show acting in conformity. That should be simple, right? Of course, we all know that that's not the case. The whole litigation is around what some people call exceptions, which I'm going to tell you, you will not use that word again. All right? So normally the way this works out is you get a file, it's like a shiny new gift on Christmas morning. You're like, ooh, new case, right? And then you read the affidavit, you're like, oh, this isn't so bad. We got ourselves this sort of case. That's not so, I think I can do it, right? Circumstantial evidence. And then you get to the rap sheet. And you're like, I mean, how long does this go? I didn't realize, oh my God. It's like, ooh, look, there's state cases in Kansas too. Jesus. So you start reading through all this stuff, and then you're like freaking out. And then sometimes, what you should do, you send a letter to the DA or prosecutor and say, tell me which 404B you're going to submit, right? And you mostly do it like this, right? You kind of go, and you run like, what? And then you light a candle and you pray that you're not going to get a response, right? That the DA is not going to file anything. And then if the DA files it, then you got to deal with it. And so what you end up doing is you sit in trial and you're like this, right? The bunny is your 404B evidence, and you're just sitting there and you're just holding it together. I mean, look at that kid. He's freaking out. He's like, oh my God, help me, right? And you're holding it together really tight, but you're trying your best while all this stuff is coming in to deal with it. And part of it is that we all know this stuff sucks. It sucks. It hurts. It's painful. Oh my God, is it painful? So basically, we have to fight against the use of that, just like we have to fight against our own instincts, my own instincts. I'm going to own it. Yesterday, when I saw her rap sheets, that woman down there, I was like, she's a fraudster. She must have been committing a fraud in this case. How the hell do I know that? I was so convinced of it. Because of the priors. We have to fight our own instincts, because what we're doing is we're giving too much power to the DAs. We're feeding into their crap. We got to fight back, right? And there's a lot there. One of the big things is the principles of 404 is just because you were a bad person yesterday doesn't mean you're a bad person today, right? Just because you've done some other stuff, a lot of other stuff, really bad other stuff, doesn't mean you're doing it today. And the courts recognize it, right? There's this idea that people understand that this stuff is so powerful, it can affect everybody. Jurors will hear it and they will go, okay, we've got to convict that person. That woman down in Florida is a fraudster. We've got to go after her. So there's this case that is in the materials that I submitted. It's Old Chief, Supreme Court case, and it cites another case called Michelson. It's got great language. I don't have up here because I want to read it, right? And this is what the Supreme Court said, which is awesome, because every time they say something nice about our clients, we should be able to quote it, because there's only like 3 or 4 times they say something nice. So it says, courts that follow the common law tradition almost unanimously have come to disallow resort to the prosecution to any kind of evidence of a defendant's evil character to establish a probability of his guilt. The inquiry is not rejected because character is irrelevant. On the contrary, it is said to weigh too much with the jury and to so overpersuade them as to prejudge one with a bad general record and deny him a fair opportunity to defend against a particular charge. The overriding policy of excluding such evidence, despite its admitted probative value, is the practical experience that its disallowance tends to prevent confusion of issues, unfair surprise, and undue prejudice. Boom! Awesome. Great. So why is it that our judges apparently haven't read that? Because in most of our jurisdictions, judges are like, yeah, come on in. Right? We have to fight. We have to be the firewall that stops that. Because otherwise, it'll all come in. So generally, what is character evidence? Okay? So the basic premise of this is, unfortunately, the rule doesn't tell you. Like, you go to 404, it doesn't define character evidence. Sometimes it's sort of like, well, what's pornography? It doesn't. So you have to look at common usage. How do people define character? And the reason I want to start this way is because actually this stuff is a little bit broader than you may think. Most of us just instinctually, knee-jerk, say character and then go truthfulness. But it's more than that. It's much more. So one of the cautions is, remember, you're distinguishing character from behavior. Yeah, behavior can be indicative of character, no question. But you have this idea of habit, right? Habit and routine. There's a separate rule for that. We're talking now about character. And so Black's Law has 2 definitions. They're kind of a little bit different, but I put them both up. It talks about the aggregate of moral characteristics which belong to and distinguish an individual person. All right, whatever. Your guess is as good as mine. You're going to have to debate this issue, right? But then the next part is the general result of one's distinguishing attributes. The way I read that is it's not just your moral character, like truthfulness. That's easy. But non-moral. Are you careful? Are you law-abiding? Are you peaceful? Do you have temperance, right? If you have a driving case, drink driving case, there are some jurisdictions where testimony about a character trait for temperance, lack of drinking, can come in. You want to look at your particular jurisdiction to see if that's something that applies. The general rule is you cannot use it to prove that someone acted in a particular way. Acting in conformity. There you go. So this rule, and one of the things that we're going to talk about with 404 and 404A and 404B is this. We're defense attorneys. We naturally assume that these rules apply to our clients, which is partially true. But they apply to everybody. Everyone. That means all the witnesses. All of them. So I'm going to tell you what the rest of my presentation basically is, and then we'll go through this. All right? And that's this. We have got to be proactive with this sort of stuff. We cannot sit and wait for the DAs to make all the decisions on 404B or character evidence. When you get the case, you have to find it. You have to find it not just for your client, but for any human being who comes into court and is going to accuse your client of a crime. Because you can. And you need to. So if someone's going to come in and swear under oath that your client was the witness who said whatever, or did something, you want to know about that person's prior bad acts. Character. Why? For all the same reasons they're going to dump shit on your client. You want to know what you can use to attack that person's character trait. Whatever that character trait, if it's relevant to your case. Maybe there's some bad acts that you can point out, right? You want to get all of that information. Some of that you will use for negotiation. Because, spoiler alert, most of your cases will never go to trial. Right? Most of your cases, you're negotiating to a better deal. So if you find some of this stuff about the victim, find some of this stuff about other witnesses, why not use it to negotiate a better deal? And of course, if you can't, then you may be able to use it at trial. But the sooner you get that, the more bang you get for your buck, right? So I want you guys to all start thinking about that as well. If you have witnesses, oops, did I lose my mic? Okay. Investigating those people so that you have an opportunity to present evidence that relates to them as you need it, all right? Now, the general rule is character evidence is not admissible to prove acting in conformity. The rule itself has exceptions. And there's some exceptions that apply just to us. Yay, right? So, first one is if the defendant's own pertinent trait is admitted. So the defendant can, if there's a pertinent trait, a character trait that relates to something, they can admit it if they want to. The problem is, then the prosecutor can rebut that. So they can present evidence to contradict that, to show that that pertinent trait isn't exactly what you say. And then the other one is sort of subject to rape shield, which is that if there's a pertinent trait that relates to the victim and the defendant presents that, subject to the restrictions of rape shield, the prosecution can then come up and rebut it and can actually provide evidence that the defendant himself has the same trait. That's sort of like the, I know you are, but what am I thing, right? So if you say, oh, that person has a particular pertinent trait, the DA can then come up and say, well, so do you, Mr. Defendant or Miss Defendant. And then there's a specific exception for homicides. So if there's a defense where the argument is that the victim was the first aggressor, then the prosecution can get up and present evidence to rebut that. All right, those are all in the rules so that you guys can get familiar mechanically with how that works. All right. Then the question is, how do you prove character? And that's in Rule 405. We'll get into the mechanics a little bit in a second, but just for right now, you can produce evidence of character by reputation or opinion. All right? And according to the rule itself, and this is the federal rules, so you want to check to see if your jurisdiction follows completely the federal rules or has some variation on it. But the court may allow cross-examination by referencing specific instances of the person's conduct. So, if someone's going to testify about reputation or opinion, the court can allow cross-examination of that witness to contrast and to check what that person knows. right? And we'll come up with a little bit more examples in a second. The second part's in the advisory note that says the cross-examination can include the attacks or basis. And I'll give you an example, and this is why it's important. Your client, this is a spoiler, may view himself like this, right? Right, so you may have your client come in and say, hey, I'm not a bad guy, right? I don't know if this has happened to any of you, but I'm not a bad guy. Why don't you get my mom to come in and testify that I'm a nice person, right? That'll be all right. I've got my mom or my dad will come in and help me out, right? So you have to explain this and deal with the client's expectations of what these rules really mean, right? You got to sit down with your client at one point and go, hey, listen, let me tell you something, okay? I know you think your mom's going to come in and say that, and we've talked to her. We're not 100% sure she'll agree. But anyway, assuming she's going to take one for the team, you see that guy over there, the DA, the one drinking orphan blood out of the straw? That one? That guy? Okay. If we get up and say that, if your mom comes in and says that, we're going to have a really awkward conversation that's going to sound like this. Miss Defendant, you said that Johnny was an angel, right? I did. Would your opinion change if you knew that Johnny had a 2003 conviction for stalking? It might. Oh, would it change then if you knew that he had a 2006 conviction for having sex with underage children? It might, right? And this will go on and on. So you've got to discuss this with your client, right? And explain all of these rules in practicality what it means. Now, your client hopefully understands it and isn't on board with not calling mom. However, your client's not your client because your client has a track record of making good choices, okay? So you're going to have to at least explain to them what this process means and deal with their expectations. Right, so how do you prove something by reputation? Well, what you do is you get a witness who comes in and says, I'm familiar with this community, whatever that community is, right? Whether it's at school, your neighborhood. I'm a member of that community, that's how I know that. And I have a basis to give an opinion of what other people in the community think about the defendant or the witness, okay? That's it. Same thing for, an opinion on the person's character trait. I've known this person for a significantly long period of time, under significant circumstances, and here's my opinion. That's it. So mechanically, what I want you to do is, if you're going to do this, if you're going to provide reputation or opinion evidence about someone's character trait, it's really straightforward and simple. Don't let the mechanics get you hung up. It really is about the investigation. It's about finding people who will actually say this about your client or about a particular witness that you need. That means you have to get off your butt and find it, because the DA is not going to find that stuff, right? Or the stuff they're going to find is just selective and it hurts. All right, so 404B, if you can get evidence of specific instances of conduct, we talked about it, if it's an essential element of a charge, claim, or defense, right? And then you can, if it's a relevant trait, peacefulness, right? Those sorts of things, then you can provide it with relevant specific instances. So, remember, if you think this hurts for you to deal with, if it hurts for your client to have to go through with this and to have their past acts thrown at them, then do it back at the DA, right? Boom! Make their witnesses go through this. Investigate it, right? Make it a tool as a sword, not just on defense. When you have someone coming into court, I could see this all day. So if you have someone coming into court to attack the credibility of your client and you think that hurts, or to show bad acts about your client, flip it around. Be very proactive on this, because frankly, Most prosecutors don't know how to handle this, right? It's like when you talk about, do prosecutors know how to cross-examine? And everyone in here laughs, right? It's the same sort of stuff. We rarely ever do what people call reverse 404, where we have 404 evidence on their witnesses. Sometimes it's because their witnesses don't have it, but we can find some of this, okay? So, all right. What can you use to support or attack character? So there's this idea of extrinsic evidence. And extrinsic evidence just means, are you limited to the questions? Right? If you're going to attack a character for truthfulness, which is mostly what we end up doing when we talk about character, that instance, can you use something other than your question? Are you limited by the answer that you get? And the answer is not necessarily. All right? So, if there's a conviction for a crime, like a felony conviction, you can ask the question, but then the rule allows you to go nuclear, right? You can bring in someone who knows about the conviction. I mean, conceivably, you can bring in the person who is there in court, taking the minutes of it. You can bring in transcripts or any other competent testimony, right? The rule allows you to do that for purposes of convictions, if you're going to attack character for truthfulness. And then there's a catch-all, which is interesting because it's discretionary. If there's something else that the court thinks is very credible, they can let it in, right? So they can allow other types of documents, other types of witnesses as permissive to attack someone's character for truthfulness, even if it doesn't have anything to do with a conviction. It's up to the judge. Now, will the judge do this if you do not ask? Of course not. Right? If you don't ask, hey, judge, I demand to do this. I want to bring in this particular type of testimony to deal with the character of truthfulness. It's not a conviction, but I want to use it. Right? Make the judge say yes or no. The judge is not going to ask you if this exists. You have to ask it of the judge. So where do you find these instances? Well, the easy stuff is stuff like rap sheets. I get it. Paperwork from other cases, witnesses in the instant case, you want to look at their backgrounds. You want to look at witnesses in previous cases. So what I mean by that is this. You're going to get a list of items from the DA or from the discovery or from another source of potential bad acts, right? Potential areas. You need to get those files. We'll discuss exactly why in a bit, but you need to get those files. What we end up doing is we look at the rap sheet and we see, oh, my client's charged today with burglary. Crap, in 2003 he had a prior burglary. In 2016 he had a prior burglary. Damn, that's 404B. The answer is no. That's part of it. You got to go get those files. You got to get the documents that relate to it. But look at other places, right? Yeah, you got to ask your client stuff, perhaps. Your client, look, if there's a co-defending case and you think to yourself, all right, that co-defendant is going to testify against my client, you may want to find out, you need to find out stuff about that co-defendant's bad acts, right? You got to think, look, man, I'm hanging around with my client, but I'm getting paid to hang around with my client. That co-defendant did it for free. What kind of weirdo is that guy, right? He's got to have some kind of problem with him. You got to go find it, right? And your client may know. People that your client hangs out with, right? Maybe your client doesn't want to say stuff, but client's mom is like, I know that person. That person was a bad egg. Let me tell you all the stuff. Because if you limit yourself to the rap sheet, you're missing other potential bad acts, right? Let's face it. Some of our clients have some bad acts they just didn't get caught for. Right? That applies to every human being. So if you limit yourself, you're missing the whole stuff. And frankly, you have an opportunity to make an end around the DA. Because what's the DA looking at for bad acts? This stuff, rap sheets. That's all they look at. Ooh, rap sheets. They're probably not finding stuff about their own witnesses that are bad acts that you can find. You need to find it. Isn't that super cool? You go into court and you got yourself an ace card. I know a bad act you don't know, right? Because it's not in the rap sheet. And the DA's like, whoa, where'd that come from? And you got the file and you got the witnesses and you can slam them, all right? Ask neighbors, teachers, relatives. You know, one of the places, my wife does divorce cases, which means I can't afford to ever get divorced because she'll take me to task on it. But people make filings all the time. They say a whole bunch of stuff in their divorce filings about property, about ownership. Witnesses make all sorts of statements when they apply for orders of protection, right? Those statements are all under oath. Those statements all are out there. Find them, right? There's a whole bunch of bad acts. I had a case where it was a person who was going to inform on my client, right? And this person made some statements in a divorce filing and basically said something to the effect of, you know, I really only hit my ex-spouse a few times, right? That's a bad statement. But not for us, right? Those are the sorts of things that we need to find and get, okay? All right. So now we're on to 404B. And most of us, when we think about 404B, because we have our case and we want to win our case, and suddenly every piece of 404B is like this, right? It's like, damn, another bad act, another bad act. It just hits us, right? And we're dealing with the fact that we're trying to win our case, but this stuff is affecting our ability to do that. So what 404B says is that prior bad acts are not admissible for acting in conformity, right? And then it says this, and this is the federal rules. It may, however, be admissible for other purposes, right? And then it lists examples. Proof of motive, opportunity, intent, prep, plan, knowledge, identity, or absence of mistake or accident. That's in the rules. How do most judges read this? It will be admissible for other purposes, and these are the exceptions. That's how the judges rule it, right? In a lot of jurisdictions, and you have to see, you know, the old adage of a good lawyer knows the law, great lawyer knows the judge. You've got to find out what your jurisdiction's like. Is this a jurisdiction where judges and the courts say, whoop, comes in automatically? If it's one of these, boom, it's like a checkbox, you go ahead. Because one of the things that we see typically when the DA or the prosecutor gets up, let's say there's a piece of evidence that we object to, a 404 piece of evidence that comes in. What the DAs will come up is they'll just give a laundry list, like this guy, right? They'll pull out a sheet. This evidence is being introduced for the following purposes, blah, 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 blah. And they do it in court, and you're like, crap, what do I do, right? So what we want to do is this. First of all, this list never says exceptions, so we should never call them exceptions. It gives them too much power. Exceptions are automatic. These are not automatic. It says may. It's always said may. I looked at it. It's always said may. But we always read exceptions, right? That's like, oh, if it checks the box, boom, it comes in. It doesn't say that. The court still has the ability to say no. Or as the sign language interpreter yesterday said, no, right? They could do whatever they want. That list is not exhaustive. It's not exhaustive. Those are examples. But if you can come up with another reason, argue that it applies, right? Argue that, hey, I'm not arguing for acting in conformity, I'm trying to show it for something else. If it's relevant to your case, that list is just a list of examples. All right? And we need to be the ones to find this evidence first. So, one of the listed items, not exemptions or exceptions, is identity. And the first thing to remember here is this, because DAs in Denver, they do this all the time. They'll be like, yeah, I'm bringing in this, this particular case for identity, proof of motive, and opportunity, right? And they list it off in court, and you're just like, oh my God, what do I do with this, right? Well, the first thing you do is you object. We'll get to that. You have to say no, right? But the other thing, too, is you got to think to yourself, is identity in dispute, right? Why are we allowing this bad act to come in to prove identity if it's a case where we're not disputing identity? So if I'm arguing self-defense, you can't get it in on identity, the prior bad act. I'm going to argue, man, I'm telling you, my guy did it. What's identity got to do with anything? What's identity got to do with it? There you go, Bridget. So what does it have to do with anything, right? Are the events substantially similar? Do we have a sense that that prior act is so substantially similar that we think it is in fact probative of identity? This is why you need to get the file. This is why you need to see the facts of that underlying case, because you're going to argue no. Even if they are, you're still going to argue no, right? They're not substantially similar. Are we talking about a common MO, right? Are we talking similar locations, conducts, items? Substantially similar does not mean the charge. Okay? Does not mean the charge. It can't mean the charge. I mean, not every burglary is the same. And then you want to differentiate all the facts, right? You want to argue that it has to be so distinctive and unusual that it must be the same person. So let me give you some examples. How many of you have had an aggravated or gun robbery in which a handgun was used? Raise your hand. Are they all the same? No, right? No, they're not. You want to argue that saying that someone had a handgun just means it's an element of the crime. It doesn't distinguish the crime, right? Everyone commits an armed robbery with an armed gun or gun of some form. It's just by nature, right? 9mm with an ivory grip. A burglary using forced entry. Well, duh, right? All of them are like that. Entry through the second floor bedroom window. It's like a signature. It's a person's way of doing something that's unique to them. It's like their own criminal fingerprint, right? Sold drugs. Well, gee, they're being charged with selling drugs. Well, how about they sold small baggies stamped 25 to life? That's different, right? The more you differentiate, the better. Similar location. Well, he committed both crimes in San Diego. Of course, he lives in San Diego, right? Okay. Similar location, the 2300 block of Zoo Drive, San Diego, which is the San Diego Zoo. You narrow it down, right? You make the arguments. You can only make these arguments if you do your work. You can only do them. But the idea is this. You're laying out to the judge all the reasons why they are different, why these things should not be probative of identity. We get to motive. And the idea of motive on the list is that there's something about that prior bad act that we think shows a reason to commit this one. Like, I've had DAs talk about, well, somebody had the motive, this is being used to show motive to do this case. And they don't explain it. Part of what I'm trying to get you to do is make the DAs do their work. Have them explain how the hell a prior burglary is motive to commit a burglary in this case. Well, how's it, right? What's the motive? Have the DAs explain it. But the idea is you want to be able to argue against it ahead of time. That's why you do the research. You anticipate your DAs are going to make stupid-ass arguments. And then you prepare for them. So, for example, one example I've seen in cases is the motive to kill arose from a prior drug deal. So let's say you have a prior drug deal involving two individuals that went bad. And so DAs have used that prior drug deal to show, oh, the reason why your client committed the homicide this year was because they were ripped off in the past. All right, that's the theory. That's different. Most people use motive as DAs for all sorts of reasons. By forcing them to explain what their reasons are, you then have an opportunity to make a better record as to why you think it's wrong. All right? Intent, knowledge, absence of mistake. This is like identity. Are these issues really contested? Have you actually made a defense that argues against intent or absence of mistake? And I'm going to suggest to you that a general denial is not enough. If I generally deny the charges, I am not raising necessarily or specifically that I'm contesting intent, knowledge, or absence of mistake or accident. And how this works up is that DAs, when you get to a trial, if you run and you disclose a general denial, where you just say, we're denying the charges, what they will then do is get up and say, this particular other prior bad act, we're trying to use to prove intent. It was not an accident. They'll mix them up. It was not an accident that this person went into this house, right? Because they've gone into other houses in the past, right? What? Okay, I guess. And your argument is, among other things, I'm not arguing, I have not specifically raised a mental state. This shouldn't apply. All right? Again, some of these arguments are arguments you make to put on the record because, frankly, you're probably going to lose a lot of this stuff with your judges. But you're like Mr. Batson. Object anyway. Cases get overturned on 404B. They do. They come back. I read about them. Right? But the problem is, one of the reasons why we lose appeals on 404B is because our record at the trial level stinks. Now, I'm going to say it here as opposed to a little bit further on because I think it makes sense here. One of the things that you need to do, and one of the problems I see with 404B on appeal, is that the Court of Appeals hates your client. Right? They hate them. Right? They view 404B the way I viewed that sign language interpreters, and I use that loosely, sign language interpreter, that person's rap sheet. They go, oh, come on. So what you have to do is at the trial level, you have to show that all this other stuff that they want to get in will prejudice your client. So how do you do that? You present the facts that show significant prejudice. You argue, first of all, you object, but then you argue those things. You present witnesses, you present documents that show the meat of why you're complaining. Because otherwise, the Court of Appeals will look at this and go, there's no prejudice, right? You didn't get hurt by it. Yeah, I know it hurts, but frankly, all evidence hurts. We're not going to say that you're uniquely hurt, all right? And then the last ones on the list are opportunity, preparation, or plan. And they kind of, I know they're in the list, but frankly, opportunity tends to be more time, location, ability for someone to commit something, right? And then most of the preparation and plan things, when you see them, they usually get rolled up in a conspiracy charge, so you don't normally get preparation and plan. There may be some instances where some bad act is being used in the past to show that that was the impetus or the start of a plan, but usually it gets rolled up in the res gesti of the case. So we got a couple of questions and issues. Boom. Is there a time limitation to 404B? No. It's not in the rule. So I have seen cases from Oklahoma, 30 years. A 30-year-old conviction was a prior bad act for use as 404B. All right? So there's no time limit in the rule. You need to know your jurisdiction and your judge. Some judges do have a problem with much older cases, right? Look, if your client spent 30 years in jail and then got out, that's a different circumstance than the person who's had 30 years and then had all this other stuff where nothing's happened, right? So you still have to litigate, investigate the gap and make the arguments as best you can to exclude older conduct. And then you also want to argue that older conduct is less indicative of those elements, those parts of 404B that the DA wants to get in. Intent, motive, all this other stuff, right? I mean, what does a 30-year-old case really mean in terms of whether or not today your client had a particular intent? Your client is the same person. That's a 30-year gap. Like 30 years ago, I was a totally different person, right? I had hair. So there's a lot of things that change with people over time. And the same thing applies. But there's no particular rule specifically. All right. How much proof is needed of the prior act? Surprise, Rule 404B is silent. Most courts view it as a preponderance of the evidence rule, right? Is there a preponderance that the other act occurred? But there's some courts that talk about what's called permissive inference. Like, what the hell is that? Is there enough evidence that a jury could have a permissive inference that that other prior act occurred? If there's a prior bad act, I mean, I have filed 404B objections in which I have said, Judge, introducing the prior 404B means that we'll have a mini trial. Has anyone ever filed one of those things? And then how many mini trials do you actually have? Well, why not? Why aren't we doing that? Sometimes we can't, I agree. Sometimes it's not going to help, right? Yeah, all those witnesses, yeah, that's actually your client. But there are some situations where it's not. Where you can actually, look, the rule allows you to bring in witnesses. If they bring in this 404B issue and you can litigate it, blow it up. Make a mess of it. Show prejudice. If you have a prior 404B where you have witnesses who say that did not happen, bring them in. Make a record that, in fact, there's a problem. You want to be tactical, and you want to make sure everything's planned, but you can do those things, right? Is prior acquitted conduct admissible? Yeah. The trend is yeah. Like, how totally suck-ass is that? Right? That sucks. So your client goes to trial, and the jury says not guilty, and then 3 years later they can bring that conduct back up? Oh my God, that sucks. They can't. You want to look at your jurisdiction. But that's why one of the things I'm saying is you got to get those records, even if it's acquitted conduct. Like, I didn't do this for a while. I'm totally going to not tell my malpractice coverage I did that. But it was the case where I just was like, oh, you won the case, right? What better proof is there that that can't be used? And the judges are like, totally different standard. They couldn't prove it beyond a reasonable doubt. We're talking about preponderance. They can bring it in. So you got to be super duper uber careful about this sort of stuff. There's a case that's called Dowling versus United States. It's in the materials where the Supreme Court dealt with this sort of a related issue on double jeopardy. And since that case, there's been a trend moving in the direction where courts are allowing this sort of stuff, acquitted conduct, to come back in, right? You've got to tell your client. I mean, hopefully they have some acquitted conduct. It's nice little yay. But then they don't think that they're out of the woods. Who has the burden under 403? Okay, in the advisory notes, 404B is not the final step. Some judges kind of think that way and kind of feel that way. But actually what happens is this. You want to start thinking about the way these rules actually apply in order. Because we end up taking this burden, like this little donkey here, okay? And it's too much. What happens is this. Let's assume in a courtroom we have argued under 404B that evidence should be excluded under one of these listing items, right? It's not relevant, it's not this, it's not that. And the judge goes, well, look, I think it will fall under one of these, and the judge will use exceptions, right? You then say, well, judge, under 403, that evidence can still be excluded under 403. 404B is not the end all. We still have to go to 403 and argue it's significantly more prejudicial than probative. And then we end up arguing it. We end up being the ones who say, Judge, it is significantly more prejudicial than probative, and therefore you should exclude it. And in actuality, it should be the government who has to argue the reverse. They want to introduce the evidence. And in fact, there's a difference in certain jurisdictions about this issue. So you want to look at your jurisdiction. There are a lot of jurisdictions that will say, once it completely qualifies under 404B, it will come in. And unless the defense argues under 403 that it is significantly more prejudicial than probative. There are jurisdictions like that. You need to find out whether you're in one of those jurisdictions. And then move to my jurisdiction. But then there's some other jurisdictions where you want to argue the reverse. And logically, the way it works is this. 401 and 402, the entire 400 section is about relevance. Does evidence come in or out? And the principle under Old Chief and Michelson is that this stuff shouldn't come in. That's the principle. It shouldn't come in. It's too damn prejudicial, right? So the presumption should be no. And why should we argue towards the presumption? It should be the other side, the proponent of that, which is usually the DAs, that have to overcome that presumption. So we should argue that they are the ones who bear the burden of showing that this evidence is not more prejudicial than it is probative. To read it consistently with the way the other rules apply. But again, some courts, and there is a trend in the United States towards this, because the courts don't like our clients, that this is viewed as a rule of inclusion. That once 404B exceptions, bad use, are met, the courts will allow this evidence in regardless of whether or not there's a balancing. So there's no 403 analysis that ever happens, all right? We want to argue the other way. So, what are the things that we need to do against all of this stuff? All right, and we heard it all this morning. You have to object. And then after you've objected, you object again. And then you object again. Because it's outrageous. It's wrong. We got to get a little bit righteously indignant. Did I say that right? We got to get a little bit more like that, right? It's bad enough our client's being charged with a crime. Have you ever, I've had cases where I have actually thought my client didn't do this crime. And I was like, this is crazy. I think we got a good defense. And then the DA is like, you're going to bring in this 404B stuff? Screw you. You don't got it. You don't have it in this case. And you're going to try to dump all this stuff and try to bootstrap this case? Sucks. That's wrong. We play too much defense. I know that's in our title, but we play way too much defense on this. We got to get mad about it. We got to show them it sucks. Option number 2, eliminate instruction, right? Draft something up. When you file it, you say, Judge, I got a limited instruction, but I want you to know it doesn't waive my objections because I don't actually think this limited instruction will serve the service here of making sure that the jury will listen to me and understand its limited purpose. But I got no option. Here you go. You do a limited instruction. Sometimes you have the DA read it before they introduce the evidence. That's great, right? So the DA's got to read a limited instruction before they start getting in this evidence, right? But those are other options. Request a hearing and notice in advance of trial, right? It's wonderful. Clog the docket up. Force the DAs to actually call witnesses. I did a 404B evidence hearing before trial in a case, and it ended up getting reversed because of some of the stuff that came out. My client lost at the trial because 404B evidence is really powerful. But we had issues that came up in the hearing. We continued to object all the time. And we had a hearing where all of this stuff came out that was really helpful for us. It allowed me to plan better for trial. Right? It allowed me an opportunity, if you can, to cross-examine some of these witnesses ahead of time and allow me to structure my defense as best as I could. Right? You can ask for, where cases are particularly complicated, to have it in trial. Worst place to deal with 404B is in appeal. Second is at trial. So you want to get it all front-loaded as much as you can, right? And that's one of the advantages of investigating ahead of time is that you know what's going to happen. Which gets us to 4 and 5. Investigate it. Speak to character witnesses. Include dismissed cases, get all these records. Be proactive and find it. Again, most of your cases will not go to trial. If you find prior bad stuff about witnesses, you can use it to negotiate. If you find it about your client, you can use it to negotiate, right? You tell your client, hey, I got some news for you. You haven't gotten to this point yet, but when we go to trial, all this bad stuff's going to come out. That 10-year offer is looking a lot better, right? Argue against similarity and temporal proximity, right? You want to argue, look, there is no special rule in 404B. I read it to you. There's no rule that says temporal proximity, the instances close to each other, means something special, right? So if a person got convicted yesterday of burglary and today they get arrested for burglary, the fact that they're really close together under 404B isn't the important part, right? It's not automatic. There's no time component. Right? So you want to argue, yeah, just because it's recent, that may be one part of it, but it's not all of it. Okay? Beware of that laundry list thing that the DAs do, where they just pull out the scroll and they start reading a whole bunch of stuff off. Make them individually justify each reason. Why? Number one, you are making a record. If they give a crappy reason for identity, you've made them make a crappy record. Otherwise, if you do not force them to justify each particular excuse that they want to use to get it in, no one ever will care. And you want to make it as clear as you can for your appellate attorney friends, if any of you do appellate work, right? They will like you. They will send you flowers, especially today on Valentine's Day, right? Where they will say, thank you, you've made my job a lot easier. I can now argue that there was a problem, right? If you have a prior bad act that is going to come in, limit what facts are going to be mentioned to the jury. You can do that. You can say, well, Judge, if you're saying that these two particular facts are the ones that are relevant, then the jury should only mention and only be told about those particular facts. Nothing else, right? So that you exclude everything else that you determine is not relevant. And if the judge says no, great. You've objected, you've preserved it for appeal. It's another basis, all right? And then when the stuff comes in, you object again, and now you have prejudice, right? You've shown why you were objecting, because this other stuff is going to mess things up, right? Require the 403 balancing. Even if you're in a jurisdiction, which is this inclusion jurisdiction, where people say, well, once it makes 404B, we're going to let it in, still object, right? That's Batson versus Kentucky. The guy in Batson still objected, even though there was no rule against it. If you object because you feel it's wrong, even if there's a rule that says you are wrong, maybe one day you will be right, right? That's what happened with Jim Crow. People didn't accept it. They fought against it. And the only people who give a crap about fighting are in this room. So you have to do that. You have to stand up against this and say, well, I get that's the rule, but I still object because I think it's wrong. It's okay. All right. The other part of this that's fun is this idea of needlessly cumulative, right? There's a 403 balance, which is, the way it's written sounds weird. It's like, look, Judge, I think the case as it is really bad. We don't need any more. It's needlessly cumulative. But the idea is, look, have they already if they have enough on identity, do they really need the 404B, right? If they got a witness that comes in and points to your client, do they really need the 404B? The answer is no. That's your answer anyway. Object to it. It's needlessly cumulative. They have other less prejudicial means, right? So I had a case, I objected, right, where the witness is accused of committing a robbery. Witness comes in, points to my client, says he committed the robbery, right? Now they're going to bring in 404B that my client did a robbery at the same way. I objected. Judge, no longer necessary. They have enough evidence as it is. Please, right? The argument, it's in the rule. Okay? Importantly, do not simply ignore the facts. All right? Okay? You just can't simply go, if they bring up this 404B, your trial strategy just can't be like that. You've got to say something, right? Because if you don't, the jury will come up with their own answer. And, spoiler alert, jury's answers typically hurt our clients, right? So you want to propose an answer. So don't ignore it. Contest or litigate those other facts, right? Sometimes you can admit it or admit part of them and deny part of them, right? Differentiate the conduct. And in the past, I've also co-opted that bad conduct to explain certain people, right? So I had a case in which my client was charged with stalking in Arapahoe County, Colorado. He was charged with stalking. He had 2 prior convictions for stalking the same person. And he had 6 other open cases for stalking against the same victim. I mean, look, if you got a hobby, right? So that's what he would do. And my argument was, well, of course, in this case, the victim would think it was him. Right? Of course you would think it was him. Right? I don't want to pat my back. He got acquitted. Right? He got totally acquitted. Right? So the idea was, I argued that there was a rush to judgment. She didn't see him very clearly in this case. It wasn't actually, there was some doubt. And the jury was, I don't know who these people were, but they were really good at going around that and saying to themselves, you know what? We're going to look at this and say, of course, we have an explanation. They liked the explanation and it worked. But sometimes you can do that, right? You've got a client who's got prior bad records. They get picked up by the police. Why? Because they're rounding up the usual suspects, right? It's a rush to judgment sort of situation. But you want to have an explanation. And sometimes your explanation is those other things didn't happen. Or they're just different. But think about it in your particular case as to how you want to do that. So we're at lunch. I want you to know a couple of things that we are all here for you support-wise, okay? If you have questions, just email us because we bounce things around. The only people in the world who care about standing up with your client when people are doing what they did to that woman yesterday, sign language woman, right, are you. And we have to fight our own knee-jerk reaction to automatically assume that because our clients have these prior bad acts, are accused of prior bad acts, that they're going to come in. And we have to say no. We have to be the last firewall that says this is where the justice is going to be determined and only as far as we want to fight that battle. Okay? So best of luck, guys. Okay.